All right, let's talk about something we've seen trip up countless inventors over our 25-plus years as patent examiners at the USPTO. It's the provisional patent application timeline. You know, that first 12-month period? It is, without a doubt, one of the most misunderstood and yet most critical windows of opportunity you'll ever have. This isn't just about hitting a deadline. It's really about laying the right foundation for your entire patent.
So it all boils down to this one number, 365. The second you file that provisional, a clock starts ticking. And let us be really clear about this. This is not some soft deadline. There are no extensions, no second chances. It is an absolute hard stop. After 12 months, your application is just gone. And trust us on this, that year disappears way, way faster than you'd ever imagine.
But here's the real insider insight, the thing we learned from looking at thousands of these files. The biggest danger isn't just missing the deadline on day 365. Nope. The most expensive mistakes, the ones that really sting down the road, they all happen inside that one-year window. It all comes down to the quality of your initial technical disclosure. How well you actually describe your invention on day one is what will either lock in strong protection or severely limit what you can claim later.
Okay, so first up, let's just tackle a huge myth right away. It's about a phrase we've all heard, patent pending. You see it everywhere, right? But what it actually means is super specific, and getting it wrong can have some pretty serious consequences.
So let's be crystal clear about something. A lot of people believe in this idea of a provisional patent, as if it's some kind of temporary starter patent. That is just flat out wrong, and honestly, it's a dangerous misunderstanding. There's no such thing. What you're filing is a provisional application. From our side, as examiners, we never even looked at them for their substance. Its entire purpose is to be a placeholder, a tool to secure your spot in line by getting you a filing date. That's it. It grants you absolutely zero patent rights on its own.
So yeah, its whole reason for being is just to lock in that official filing date. In our world, we call that a priority date, and that date is everything. It becomes the line in the sand. Any other invention, any public article, anything that comes after that date, well, you can prove you were there first. It's like planting your flag in the ground on a specific day and saying to the world, my invention existed right here in this form at this moment.
All right, so you've planted your flag. Now what? Well, from what we saw on the inside, this next year is absolutely not for sitting back and relaxing. This is a time for focused, strategic action, not for waiting around and just hoping for the best.
You know, a successful year really has a game plan. The first few months, that's when you should be refining your invention, really digging into the market research. Then you get to the middle of the year, and this is crucial. It's time for a professional patent search. You have to know what's already out there. Why? Because that search is what helps you and your attorney draft stronger claims, claims that will actually stand up to examination later on. And you'll notice we are targeting month 11 for that big non-provisional filing, not the last minute of month 12. We tell everyone this because, well, things go wrong. Websites crash, last-minute business decisions change. And since that deadline is absolute, you just can't risk leaving it to the last day. It's just not worth the gamble.
Okay, now we need to talk about a huge pitfall. And I'm not kidding, we saw countless inventors, and frankly, even some attorneys, fall right into this trap. It all comes down to that priority date we just talked about, and a massive misunderstanding of what it can and can't do for you.
So let me just ask you this directly. Let's say you file your provisional, and then during that one-year period, you make some awesome improvements to your invention. Are those new improvements covered by your original filing date? You know, the common assumption is, yeah, of course. But the actual answer, the one that matters in patent law, it's a hard no.
This is a textbook case we'd see all the time. Imagine you file a provisional, and it describes feature A. Then, 6 months later, you have this aha moment and you add a brilliant new feature B. So when you file your non-provisional claiming both A and B, when that landed on our desk, we could only give the early priority date to the claims covering feature A. Why? Because feature B is what's called new matter. It wasn't in the original filing. So it gets a brand new, later filing date, which is a huge problem. It could leave your best improvements completely vulnerable.
This was the rule we lived by every single day at the office. Your non-provisional application only gets to claim that valuable early filing date for things that were adequately disclosed in the original provisional. So what does that mean? It means a vague, napkin sketch description you filed on day one is not going to support the super detailed, robust claims for your finished product a year later. It just won't fly. The quality and the depth of that very first document, that's everything.
Okay, so what happens when the music stops? When that 365-day clock finally hits zero, everything we've been talking about, the priority dates, the new matter, it all comes to a head. And from what we've seen, it usually ends in one of three very different ways.
First up, you've got the best-case scenario. Success. You filed a solid, well-drafted, non-provisional application before the deadline. Your provisional did its job perfectly. It technically gets abandoned, but that all-important priority date it's established gets securely attached to your new application, which then moves on into examination. That's exactly how it's supposed to work.
Scenario 2 is, well, it's a reset. Here, you missed the deadline. But, and this is a huge but, you never publicly disclosed, sold, or published anything about the invention. If that's the case, you can basically start over and file a new provisional. The catch, though, is enormous. You completely lose your original priority date. It's gone. Any competitor who filed during that one-year gap is now legally ahead of you.
And then there's the worst-case scenario, forfeiture. This one is brutal. This is what happens if you publicly disclosed your invention, maybe at a trade show, in an article, or by selling it, and then you miss the deadline. That combination is toxic. Under U.S. patent law, this can mean you have permanently forfeited your right to patent that invention. It's not a reset, it's game over. So, after all those years spent inside the USPTO, reviewing these exact scenarios play out day after day, what's our final piece of advice? If you only remember one thing from all of this, we really hope it's this. A provisional application is only as valuable as the technical disclosure inside it and the strategy surrounding its conversion. See, just filing the application, that's just step one. The real value, the part that we as examiners were always looking for, comes from a detailed, high-quality disclosure that can actually support the invention you want to protect a year from now, combined with a smart strategy for using that 12-month window to your absolute advantage.
So if you're thinking about a provisional application, or maybe you're already inside that 12-month window, we'd encourage you to visit our website. You can see a much more detailed breakdown of this whole timeline, or you can schedule a direct consultation with our team to talk through the right strategy for protecting your specific invention.